Chairman, thanks for holding this hearing. Thanks to all of the witnesses for being here. Ms. Harper, if I could just start with you, I want to thank you for the great work that you do on antitrust enforcement. We've worked a lot, your organization, my office, so thank you for everything that you do. And something that you are very focused on is revitalizing antitrust enforcement, because revitalizing antitrust enforcement is really about protecting our markets, promoting competition, and getting a good result for consumers and workers. Is that fair to say?
Very fair, and other businesses as well.
And other businesses as well. Yeah, well said. Let's just talk, though, about some of the barriers to antitrust enforcement, effective enforcement. This is something in just my short time in the Senate that I've seen over and over and over again, is that antitrust suits that you would think should be brought don't get brought by the government. Suits that you think should be pursued don't get pursued. So can you speak to some of the barriers to effective antitrust enforcement that you see out there that you're familiar with?
Well, I mean, I do think big tech is an area where we've been quite impressed with just the wide range of suits that have been brought by enforcers and bipartisan enforcers across multiple administrations at this point. And that's encouraging and something that we've already discussed a bit today at the hearing. But usually what is most challenging for enforcers is having enough resources. I mean, these guys are often outgunned by the big tech firms that have unlimited budgets. The former chief legal officer at Google said publicly that they had about $1 billion to manage any sort of legal risk that was presented to them as a company. And we have enforcers that even in these trials will have about 1/10 of the resources that any individual defendant that they're taking on might have. So put all of that on turbo speed when it comes to big tech, and the inequity in resources is quite stark.
Yeah, that's startling. $1 billion, and that's versus government enforcers who have the resources of the government. I noticed that in the Clayton Act, anybody who's familiar with our antitrust statutes knows this, the Clayton Act, 15 U.S.C. Section 15A, the statute says that any person, I emphasize any person, who shall be injured in his business or property by reason of anything forbidden in the antitrust laws may sue, therefore, in any district court of the United States. That's a private right of enforcement. I mean, so the Clayton Act allows private suits, and yet it's usually, there are private antitrust suits out there, but usually it's government suits that we see. Is that because of the resource imbalance, do you think?
Yeah, I mean, it can be difficult to find a plaintiff's attorney that's willing to take on the risk. And again, when we're looking at bringing a suit against big tech, you are taking on not just the biggest giants of the United States, the biggest giants of the world that have unlimited resource. That can be quite intimidating for anyone who's running their own law firm.
Absolutely. Mr. Basbas, let me just ask you in this respect, your company has suffered, I would say, maybe more than anybody at the hands of Google and their anti-competitive conduct. Did your company bring an enforcement suit, a private enforcement suit under the Clayton Act? And if not, why not?
No, I don't believe we have. As we were just talking about, it's very resource intensive and time intensive. And, as a startup and, over our 15-year course of existing, you have to make trade-offs. We're trying to run a profitable company, which DuckDuckGo is. And so we're not just trying to raise more and more money and build up more and more equity and debt over time. And so you have to sort of pick your battles a little bit. And so that's not one thing that we've prioritized.
Yeah, that makes total sense. And I'm sure it's an entirely rational decision on your part. Here's where I'm going towards. Here's what I'm getting at. I just wonder if it's time that we took a little bit different approach to antitrust enforcement. I wonder if it's time that Congress, in addition to pursuing some of the other goals and goods that we've been talking about today, I wonder if it's time we revisited the power of private suits in antitrust enforcement and began to make those viable again. Courts have closed down access by private parties to antitrust enforcement suits by imposing injury and standing requirements that I think, frankly, are somewhat suspect. We could fix that. We could allow class action suits in the antitrust context. We could open up the courtroom doors and allow private parties access in such a way that it would make economic sense to bring a suit, and you'd have a better chance of prevailing. I just wonder if it's time we start thinking outside the box a little bit, or maybe it's not outside the box. Maybe it's getting back to first principles, because this is, after all, how the Clayton Act was written. I mean, it was written to allow not just government enforcers, and we understand the importance of that, but it was also meant to allow injured private parties to get into court and have a real shot at enforcing the law and recovering damages, treble damages. under current law. Maybe we ought to increase those damages awards. Maybe we ought to change some of the injury and standing requirements that the courts have imposed that I think, frankly, are not there in the text, the history of the Clayton Act. Did I see you raising your hand, Professor?
I was going to say
call on you.
Thank you. I was going to say where you were ending up, which is we need to increase the incentives and rewards for bringing these lawsuits. We have bounties in other areas, such as securities laws. We can bring that into antitrust. So, and that's good on both sides, by the way. It's good for incentivizing the lawsuits to be brought. It's also good for deterring anti-competitive conduct because the penalties are greater.
Yes, exactly. Terrific point. Terrific point. And there's something that is, I think, particularly market reinforcing about private suits because you have private actors who in real time are responding to harms. If they are properly incentivized and able to get into court to enforce their rights, that's good for the company. That's good for all of the other people who are in a similar position. It's good for the government. The government is not expending resources. It's good for the market. As it turns out, the people who drafted the Clayton Antitrust law were pretty smart, actually. They had a good intuition 100 years ago, and maybe it's time that we made better on that promise. Do you want to say something, Ms. Harper? I'll give you the last word.
I was just going to add, one, I love the creativity of different ideas of how we can take on the power of big tech. I think it's an all hands on deck situation, and every approach that we can adopt, we should be to stop their lawlessness. I will just add, though, and we hear this from a lot of market players, that it can also be quite scary to take on that public lawsuit for fear of retaliation. We know it's happening behind the scenes, but once you become the named party in a lawsuit, that can also heighten quite a bit that risk. And so I do think it's a both and, funding the antitrust enforcers, making sure they have the resources to bring these suits on behalf of a lot of the businesses who can't for themselves, but then also encouraging private suits as well.
Yeah, absolutely. I agree with all of that, and that's absolutely correct. I think absolutely correct. I'll just end with this. It's a point I've been making recently in other contexts, but there is something that is uniquely attention-grabbing to these companies about facing a jury, having to face a jury maybe and with a competitor who's sitting on the other side of the table and facing a judgment that will run into the billions of dollars. It really gets the attention of these CEOs and frankly their shareholders. I remember the FTC fined fined Meta not that long ago. It was a pretty large fine. Meta didn't meaningfully change their conduct. Their stock price went up the next day after the fine was announced. It's ridiculous. How would they like to face like a billion lawsuits that could run into damage totals of tens of billions, hundreds of billions of dollars? I don't know. Seems like that was the intuition of the drafters of the Clayton Act. I'm way over my time, Mr. Chairman. You've been super patient. Thank you.